All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Catherine Carlson presiding.
Welcome, be seated. Case now at hand is file number WC246561, entitled Ray Appleby versus Minneapolis Park and Recreation Board. As you will see, we have a full 5-judge panel. We have Chief Judge Patty Millen, Judge Tom Christensen, Judge Deb Sundquist, and Judge Sean Quinn. You have both been here before, your experienced counsel. Please remember that you each have 15 minutes. If you want to reserve any time, you're in charge of keeping track of your own time once you're seated. And if you get back up, the marshal will put the remaining time back on your clock. Also, so that you are both aware, this is being live streamed and recorded, so please do your best to speak up. Mr. Sisk, you are the appellant. You may proceed.
May it please the court, counsel. I will try to reserve a couple minutes. I know it's always hard. I always find that I kind of run out of time here with the 15 minutes. So I'm going to kind of just get to what I believe are the heart of the issues here with regards to this case, is we're asking the court to reverse the trial judge's denial of workers' compensation benefits. One of the main issues that I see and that this court has to address is the res judicata collateral estoppel. First, we do not believe that there is res judicata or collateral estoppel, for the sole reason that the RSD, complex regional pain syndrome, claim was not made at the time of the initial decision. This court has heard from the previous decision, which related to the right ankle and the bilateral knees, but the court did not address the complex regional pain syndrome and the RSD. Issue preclusion, as it's stated under res judicata, does not apply if the issue at stake was not specifically decided in the prior proceedings. One of the issues that we addressed, which we stated on the record, was whether the February 27th or whether the 2018 date of injury is a substantial contributing factor to the employee's diagnosis of complex regional pain syndrome and CRPS related treatment. That was not an issue at the first hearing, as that was withdrawn. The second, even if the court were to determine that collateral estoppel or res judicata does apply, it is not to be held so rigidly that it would drastically affect and limit my client's right for benefits. So in other words, the doctrine is not to be applied rigidly, and the focus is whether its application would work an injustice on the party against whom estoppel is urged. And the reason why I say that it would be an injustice is because when we look at all of the evidence, and I know that's part of what we're arguing here today, but we look at the IME doctor, we look at the treating doctor, all of them believe that my client suffers from a form of a neuropathic pain, RSD, complex regional pain syndrome. Whether it's denied as CRPS, causalgia, complex regional pain 1 or 2, however you want to define it. If it looks like a duck, walks like a duck, it must be a duck. And that's the argument here. And that's why we have the rules under 5221, which define when we have these types of symptoms and problems that my client experiences, we don't just place it and put it in a small little box of complex regional pain syndrome or RSD. There are other factors. And this court has addressed it previously in other decisions where we look at it and it fits within that diagnosis. That's why when we look at the IME doctor, he talks about fragments. He talks about, now he doesn't come out and specifically state, I think, and that's one of the issues here, but he doesn't say that my client does not have RSD or complex regional pain syndrome or even symptoms of that. Instead, he admits and says, hey, he does have it, at least up to the time of the evaluation when he was able to see it. And so we look at Dr. Agre, we look at the other physicians in this case, they all support that diagnosis. Even Dr. Pena, when he says unknown etiology, that's one of the things in the rules when we don't know the mechanism of the cause or the cause of those symptoms, an unknown etiology. That's why we have this overlapping causalgia, complex regional pain syndrome rule to fit for this exact reason. So with that, again, we don't believe that res judicata or collateral estoppel, and collateral estoppel, the same thing does apply, is that like res judicata, we do not apply collateral estoppel rigidly, but focus on whether an injustice would be worked upon the party whom the estoppel is urged.
Mr. Sisk, I'm going to interrupt you for a second. Would you agree that many of the bills that you presented at this hearing were the same bills that you presented at the prior hearing?
Correct. There were a number that were. One was the Medica. There's a bill of October 8th of 2020, which was not part of Medica's intervention claim. But again, and I think that's the issue that this court has to address, and this is where we differentiate it when we start talking about claim and issue, because we start talking about claim, and if we look at it rigidly, we say claim, well, you have medical bills. But the theory and the approach for which was specifically defined at the time of hearing. We knew we were not pursuing complex regional pain syndrome or RSD. Now, one of the things that counsel had written in their brief was that, well, we should have withdrawn those medical bills. Like, we should have not brought those. But what a mess that would have made. It would have even made even more mess, because if we would have withdrawn those, then to try the case again now with the ankle and the RSD, with the PRIA decision, it would have just made it a large issue. You know, one of the things that this court system that we have to deal with is a quick and efficient delivery of benefits. And for the reason, the complex regional pain syndrome, RSD, was not ready to be tried at the time of hearing. Now, it wasn't me who tried it, it was my counsel. But regardless, even at the time that we tried it, it's a good thing we didn't, because we didn't have the IME doctor of Dr. Adafalafa, who did support the claim. And we have the second report from Dr. Agre, we have an updated MRI, and we have the scans. And so, yes, those bills are similar, they are the same, but the issue and the theory for payment of those are different than what was being claimed at the first hearing.
But let's say I 100% agree with you that, you know, our res judicata, collateral estoppel don't apply because you clearly did not try CRPS the first time. The judge he didn't make a finding, but he made a comment in his memorandum that essentially, you know, I just don't think that CRPS was proven. And he specifically pointed out to Dr. Pena's report, who in this first report from the first trial and this new report from this trial, in both circumstances said basically the same thing. I don't know why. I don't know the cause. He also said reasonable, necessary, and causally related, it seems to me as almost reflexive. But in the actual body, he says, I don't know why. I don't know why this man has it. If the judge is persuaded by that, isn't it just substantial evidence then that you did not prove the claim, in his opinion?
I think it's unsupported. I'm going to give you a sports analogy. You know, if I play football and I punt, am I giving up? Am I forfeiting the game? No, I'm moving on. What did the doctor do in this case? The doctor said, I don't know. Said, I don't know the etiology because I'm not an expert. I don't know. That's been the theory of this case from the beginning. And I don't know what more. I mean, if we had Dr. Pena in this room, he would probably say, I don't know, because I don't handle complex regional pain syndrome. We had to have Dr. Adafalafa, a specialist. We had to have Dr. Auger. We had to have other specialists to be able to diagnose this. But if you read the records of Dr. Pena, which I've tried to say, is he's saying he's got complex regional pain syndrome. He's even having to write restrictions for these multiple times because the pain doctors and work comp will not accept it. He's having to continuously come back. He's not saying that the guy's malingering somatization or making anything up. So the belief of this, that there is nothing, or that Dr. Pena, the reliance, is unsupported by the evidence. To say that a doctor says, I don't know, that means that if we go to any doctor.
Saying I don't know the cause. He's not saying I don't know. I mean, he does also he's hemming and hawing a little bit on the diagnosis, but clearly I agree with you. Dr. Pena says there's something wrong with this man. Yep. There's clearly something wrong with this man, and I'm going to treat him. I just don't know the etiology, the cause.
And that should fit under 52236-305. If you read the last line under there, under subsection, I'm sorry, I don't have it, but it says there's no other explanation for the degree of pain and dysfunction. There's no question. Even the IME doctor is saying that my client has dysfunction, has pain, has allodynia, has the non-anatomic distribution of symptoms and problems. Every doctor in this case does, even Dr. Pena. If we want to read it within this limit narrative view, and then to try to create this so that way it's supported, it's against the substantial evidence in this case. Common sense does not rely for us to rely on Dr. Pena when he does the proverbial football punt. We can't rely on his opinion because we have other doctors. That's why Dr. Agre was submitted, because Dr. Pena's opinion basically said, I don't know. I don't know what's causing this. The other issues in this case outside of the, is the fact that the judge failed to award payment for Summit medical bills for the injections, for the treatment that my client has had post hearing and decision from our last trial. And the substantial evidence in this case supports that. One, by Dr. Agre, two, by Dr. Katia, and well, third, my client's testimony, and four, the medical records themselves. And so Dr. Adefalafa, the only other doctor who has seen my client post the first hearing, says, I can't comment on the left knee. I can't comment on the right knee. I can only comment on the complex regional pain syndrome, RSD symptoms. And so when the judge in this case indicates that, one, the records aren't even there, and two, there's no other additional evidence, substantial evidence says otherwise.
Mr. Sisk, it seemed clear to me from your brief that you interpreted Judge Marshall saying that there's nothing new here as that he didn't review the records. Am I correct?
That is my insinuation. Obviously, I don't know. I mean, and only Judge Marshall would know. So we can only rely on what's contained within the memorandum, what's contained within this information. But if one is to assume, then when he's saying there's nothing new, and there's obviously new information, new medical causation opinions, again, we believe that substantial evidence supports it otherwise. So I'm going to reserve my remaining time here for further.
I'm going to screw you out of some of it.
Okay.
I want to clarify the Gillette claim. There's a beginning of the decision issue. Is there a Gillette injury? There's only one finding which you appealed, which is there is no Gillette injury. In your written closing, you said something to the extent of, we concede that we haven't proven a Gillette injury. Is Gillette injury out?
Yes.
Okay.
It is out. Correct.
All right. I just wanted to confirm that.
Yes.
Mr. Sisk, looks like you have just over 3 minutes left.
All right. Thank you.
Rebuttal. Yep, Ms. Charleston, please.
May it please the court and counsel, I'm going to, as a respondent, mostly respond to what Mr. Sisk has argued about. But first, I'd like to cover the question of what is actually on appeal here. In my brief, I outlined that the only elements or issues that were appealed were those number 23 through 26 in order 1 and 2. And throughout Mr. Sisk's argument, he talks about the judge not looking at anything new and not finding anything new, and that there were new things that happened. Well, anything that's specifically found in findings 1 through 22, appellant did not specifically appeal. And so I would make that note to the court that you're limited in what you're able to actually review. It's those 4 conclusory types of findings and the orders 1 and 2.
So, counsel, do you believe that the judge's subdivision of ultimate findings of fact and conclusions of law, and then underneath those, all of those are appealed based on a preponderance of the evidence fails to show standard that counsel has waived his right to the specific findings contained in
I'm-
the 1 through 22 before that?
I'm saying that the rules as written in 176, oh, now I'm, look at it, because 176421 subdivisions 6 and 3 indicate that specific findings need to be identified. So if you look at the plain reading of that statute, it would seem to indicate that those findings, each separately numbered, are their own findings that need to be identified and appealed. So I guess that's a long way of saying yes, Your Honor.
You believe it's clear, concise, and brief in the rule?
Yes. And to point out, Dr. Augry's, appellant says that he thinks or insinuates that the judge may not have reviewed the records. But if you look at finding 21, he does directly address Dr. Augry's May 1, 2023 report. So it's very clear that he read the report. What he wrote down and took from it is within his discretion to do. That's what the hearing judge is supposed to be doing, and that's what he wrote. Again, I'd like to take issue with the argument appellant makes regarding Dr. Altafala and his report. Dr. Altafala says very clearly that the employee does not have CRPS. And in the first hearing, though they did reserve the CRPS claim, that is the only issue that they resolved. They didn't resolve causalgia or a neuropathic pain or unexplainable pain or anything of that nature. They reserved CRPS, and the reason given was that it was not ready to be heard with all the other issues that related to the work injury. However, if you look, Dr. Augry issued a report that was entered into the first hearing. And in that report, he addressed CRPS. In that report, he said the employee had CRPS. In that report, he even went so far as to rate the permanent partial disability of the CRPS. And in his new report for the second hearing, second time around, second bite at the apple, whatever you want to call it, he refers back to his first report and says, like I said in my first report, he has CRPS. So as far as there being new information with regards to the CRPS, there really isn't. And I think that's the kind of shorthand that the judge was using when he was saying, I don't see anything new here. He is very familiar with what happened in the first hearing, very familiar. He knows what happened on appeal. He knows what happened at the second hearing, and he made his determinations based on all of the knowledge. The doctor reports that were submitted in the first hearing were submitted in the second hearing. Dr. Augry may say the knees needed injections, and he's the only new report that says that. But at the end of the first hearing, the judge limited the medical treatment, saying continued medical treatment is not warranted at this time. The medical treatment that was continued here was injections into the knees. Again, he's looking at the medical documents that were submitted at second hearing, may not have been compiled after the second hearing, but saying that this is not new. The gentleman had underlying degenerative chondromalacia conditions as well, and he decided that based on the records as a whole, the employee did not prove up that these injections that occurred, one after the first hearing and the second after this appeal was issued, that those two injections really related to the work injury. He couldn't find the causal connection there. And that's his that's within his power and within his discretion to do.
Ms. Charlson,
Yes.
and just to kind of circle back, you had mentioned that the only claim reserved was the CRPS. But isn't the underlying issue whether the treatment is related to the work injury, regardless of the diagnosis?
That is the answer that we want to get to. But that was considered in the first hearing as well. In the first hearing, the employee was saying, hey, this pain problem, whatever, was caused by my ankle injury. Not by the CRPS, but by my ankle injury. I'm holding CRPS out over here, and for some reason, it's not ready, but we have a doctor's report and we have all of the things that would be needed.
So the same treatment, but a different theory.
Correct.
Okay, thank you.
And that's what that goes into the elements of res judicata and collateral estoppel. And this is exactly the kind of situation that those doctrines are intended to avoid. You know, if I come up and say, okay, I broke my arm, and now I'm going to say that it's not really the broken arm, but it's the pain after the broken arm, which may or may not be RSD, maybe causalgia, maybe, you know, it's the spaghetti kind of thing where you're throwing spaghetti against the wall and seeing what sticks. Yes.
Do we even need to address res judicata and collateral estoppel if this is just a substantial evidence case? Based on, or
Maybe I'm being a little spaghetti and arguing res judicata and collateral estoppel. But I do agree with you, Your Honor, that we look at these kinds of the issues of fact with Hingemühl in mind, and you know, giving the hearing judge the right to make the decision with regard to what the medicals speak, which medicals speak to him. He's considered everything. Which medical opinion speaks to what he believes the record as a whole, the case as a whole means. So yes, there is deference to the hearing judge.
All right, so let me ask you about that. So Dr. Kadia, if I'm pronouncing that correct, there's no new opinion from him. There's some new treatment records, but no new opinion from him, correct?
Correct.
Dr. Agri does make some opinions in his report, in his second report, about the knees and the treatment for the knees being related to the work injury. And Dr. Atufala says, I'm not talking about knees. So that's the only new opinion that we have, correct?
That is the only new opinion. However, submitted for the second hearing were the opinions regarding the knees at the prior hearing. And at the prior hearing, the judge said, medical stops at this point.
Okay. So, and that was going to be my question, is there anything about Dr. Agri's opinion, the second report, that's any different from his first report relative to the knees, not about the CRPS, but relative to the knees?
Relative to the knees, the doctor says that the employee is experiencing pain and requires injections, and his opinion is that there is a causal connection between the two. Dr. Happy, with her opinions, and the other doctors that addressed the opinions and the law of the case from the first, was saying that as of these specific dates, treatment for the right knee ceased to be causally related, and treatment for the left knee ceased to be causally related. And at the second hearing, the judge was tasked with determining if the new treatment to the knees was causally related to the work injury. He had found nothing new, meaning he didn't see any kind of explanation for why these same treatments, these injections, would be causally related to the work injury.
So there needed to be something else the work injuries has reared its ugly head again. It had stopped and now it's come back and here's why, or something like that from a medical professional.
Right, there needs to be, this is how we connect these treatments to that injury back in 2018. And with that, I'd like to reserve the rest of my time, unless
Okay.
there are other questions at this point.
Any other questions? Okay, Ms. Charleston, you have just over 3 minutes.
Thank you.
And Mr. Sis, would you like to present anything for rebuttal?
Yes, thank you. So I'll provide some comment first. When we talk about collateral estoppel, the difference here is that this issue was reserved. The example that counsel had given was if there was a situation where, a broken arm and you don't bring a theory, you don't bring it up to the parties, you don't bring it up to the court, but this was brought up and this was reserved and there was no objection. Again, I mean, what could have counsel done? Counsel could have said, well, I'm objecting to these medical bills. I don't want to have it. Is that her burden? I don't know. Is it my burden then to have reserved and withdrawn those medical bills and said, no, we're not going to do that? No. Instead, we advised the court of that issue. Now, when we start talking about substantial evidence, if I was looking at this case after the second hearing, not knowing what is going to be admitted or denied, as a practitioner, when I'm looking at my clients' knees who have chondromalacia, I get a report from Dr. Agre. If that's not enough, if I need something else more than a report from Dr. Agre and medical treatment, then I think we have some issues, because I don't know if I would take this case then and help my client. And that's the fear I have right now, is that I don't have any answers from the judge. I don't. I have chondromalacia. I have 2 bad knees. I have permanency, but I have him saying it's not related. Am I going to take another third bite at the apple at a $5,000 medical report for Dr. Agre or even Dr. Katia, where Summit charges, to help out my guy? No, I won't.
Mr. Sis, I've got a question on 1764217.
Yep.
You appealed only findings 23 through 26. And the statute's pretty clear. Would you not agree about what you appeal and what you forfeit when you don't appeal a specific finding?
Correct.
Having said that, if we were to find that, in fact, under substantial evidence and Angamule, the preponderance of the evidence does show what did or did not happen, and whether you met that burden, wouldn't that be it?
Well, do I have to appeal a finding if it's not complete? In other words,
I believe you would. I would.
yeah, see, if I see a medical note, or if the doctor or if the judge says something and it's incomplete and doesn't include all of the necessarily details, I don't know if I necessarily, because I'm not objecting to what he's saying. What I am objecting is, in this case, is that he has not included all of the evidence.
But your inference in your appellate brief is that he didn't read all the evidence, and
Correct.
we all know that you don't have to state all the evidence to prove that up or to dispute that. If the compensation judge says under these findings and ultimate findings that either you failed or you succeeded in proving your case, and you appeal only the preponderance of the evidence quotes from 23 and 26, aren't you limited then to the findings of facts from 1 to 20?
I don't believe so, because I can't appeal what he doesn't have in there, right? I
Why
can't.
would you appeal
I
findings
can't
1
list
to
out a finding when it's not included as part of that information if I'm necessarily. So for example, if he's saying that there's an injection, which he does, he states that there's an injection. But if we're talking about the relief from the injection, how did my client do after the injection? How the testimony? Do I need to
I
appeal?
don't think you're understanding my question, so let me,
Sure.
if I may. You appealed findings 23 through 26. They were ultimate findings of fact and conclusions of law. So the judge subcategorized those in his findings in order, I believe, for a purpose. They're the ultimate findings of fact.
Correct.
And you didn't appeal the findings 1 through 22. So those findings stand.
Correct.
So why would we not just review this under substantial evidence and Hangamule, considering what 176.421 says?
So I guess if the court is saying that, then I am to then appeal all of the findings, and I should do that on any appeal case, just in general to do it. I don't know if that's the intent. I think the intent is that if you have a specific objection to the finding itself, the finding as to how the judge says, if the judge is saying that the light was red, but it was actually green, then that's something that I would object to. But if a judge is just stating a summary of the medical note or record, and I don't dispute it on its face, in other words, that's what it is. It's a fact.
You think a judge's ultimate finding of fact is just a summation? That's what you just said.
I think certain findings can be.
I agree.
Yeah.
I don't want to move to the general. I want to talk about the specifics and your findings in order. Do you think this compensation judge's ultimate findings of fact and conclusions of law are merely a summation?
I think those are conclusions. I think they're conclusions based on what? And you're right. Is it based upon the review of this above information? And what about excluding the others? I don't see, there's no finding about the injections my client had at Summit in 2023. How do I appeal that? Do I appeal all of the findings on that? No, I don't, because there's no specific finding that pertains to that issue. So I guess that's how I've viewed it, and that's about my practice. So if it's a pro tip, if it's a lesson learned, hey, I'm all for it, and it will be one through whatever it may be. But instead, what my hope is to lead at least this court in counsel, in saying, hey, these are the issues that we ultimately have, that we are,
And
being presented with.
Mr. Sis, thank you for asking Chief Judge Millen's questions, and
Yep.
you are
Thank
used
you.
your time plus a little more.
Sure.
So thank you.
Actually, I do have a
wait.
question. Do you have a question?
Oh,
Yeah, I do too.
Yeah,
So
I'm sorry. Yeah,
You're back.
thanks.
You're back.
I shooed you along too soon. I'm sorry.
Go ahead, Deb.
Yeah, Mr. Sisk, I'm looking at finding 22, and it's Dr. Altofola's findings with the CRPS. And the second to the last sentence says, Dr. Altofola noted it was not possible to ascribe specific deficits to the lateral plantar nerve without an EMG or nerve conduction study involvement of that nerve. Has there been any EMG or nerve conduction study that you're aware of?
I don't believe so.
Do you think if that happened that you would have another crack at this?
It's would I have a crack or would I take a crack? That's a good question. Yes, there's always that possibility, when we don't resolve, if the injury is not resolved or we settle out the case, there's always that opportunity to be able to, approach that. But yes, I'm not aware if there's an EMG that's been done on this case.
And along the same lines, almost the rhetorical question that you asked earlier. So the first decision is made. Judge Marshall says, as of these specific dates, the care is no longer related, and this court affirmed. And then you bring this new claim saying, okay, well, but after that, now they are related. And Judge Marshall said, there's nothing new here. You're saying, well, wait a minute, I got Dr. Agri's report, I've got the medical records from Dr. Kadia and so on. This is what an interpretation of that, which is that Dr. Agri's opinion really doesn't say, as I mentioned to Ms. Charleston in my discussion with her, hey, it's the knee injury or the work injury has reared its ugly head again. It just seems to be the same kind of report. Is that a fair interpretation?
No.
Okay,
No.
and why not?
Well, there was another evaluation. He was able to review the findings in order of the court. He was able to review your prior decision. He had that opportunity. He was posed with questions. If you look at the record, there was a detailed.
And you're speaking of Dr. Agri.
Dr. Agri. Yep.
Agri.
Yep.
Okay.
Yep. Dr. Agri's background letter, where he specifically asked all of those questions, those interesting questions that were asked and posed with the court as to, hey, how it's changed, what's different, why is this treatment reasonable and necessary? And this court hasn't put a significant burden on an employee for us to CSI a causation opinion. If a doctor says that it's reasonable, necessary, and causally related, that's enough. And if it's uncontroverted, then it even holds more weight. There's no opinion with regards to that treatment that was offered into the record that contradicted that. And as I was saying with the other treatment, if we look at, what was paid, what was ordered, and I outlined that in my brief, and you'll see that there were medical bills, for CRPS that was awarded that the judge said, and that was with Dr. Pena. And there were 2 notes of it. There was an injection that was paid. Counsel, after the Dr. Adafalafas, they paid the TRIA note. They paid that bill. That's why there was no intervention from them. That was paid after this IME.
Mr. Sis, thank you for answering
Oh,
the
sorry.
questions. Oh,
Yes.
no, but before you sit down, let me look over here. Any further questions? Anyone?
I'm good.
Thank you very much.
My apologies.
No, thank you. Ms. Charleston, you had reserved 3 minutes, and Mr. Sis just had an additional about 6 minutes. So in all fairness, you may have equal time. Don't feel like you need to fill it, but it is certainly yours if you need it.
I should speak in the microphone. Thank you, Your Honor. A couple of things. At the start of appellant's rebuttal, he says, why didn't the employer at the first hearing object to their submission of the medical records that should relate to CRPS? Well, we're not in the position of deciding what makes up their case in chief. And when I find out at the hearing, minutes before we start, that the CRPS claim that was made at the start of the filing of the claim petition is not ready to go, I'm understandably a little taken aback, particularly because Dr. Augury has a report in there, says he has CRPS, says he has PPD, all of the elements that you would expect to find in improving up the case. They say, no, we're not going to do that right now. We're going to wait and see what we get awarded here, and then we're going to take a second crack at it. So, another sort of twist to that is that even if I object to the submission of an exhibit at hearing, it's not guaranteed that that objection is going to be overheard. It's more likely going to be your objection is noted, that'll go to the weight of the evidence. So that is saying that the CRPS bills that were, or the bills that were submitted at the first hearing should have been objected to by me doesn't hold water with what happened in this case.
Ms. Charleston, so I want to make sure I'm clear on this. So you're saying that the burden's not on you to object to a reservation of different theories, that the burden is on the employee to bring all theories to prove the payment of the bills.
That's true.
Okay.
Yes.
Thank you. Just want to be clear.
And the case just in general is the burden is on the employee to prove his case up, to have the elements required to prove its case up. In regards to if there needed to be an EMG, well, Dr. Altafala's report was presented in the first hearing, and that, actually, I don't know if it was. But the report of Dr. Altafala was presented before the second hearing took place, and if an EMG was necessary to prove up the employee's case, then an EMG could have been done and included in the evidence to support the claim. When talking about what is and is not on appeal here as far as the findings go, Mr. Sisk went to the intent of the rules, and when you have a statute, a law that is very clear, very plain, English written, you can understand it, we don't go to the intent. And if we go to the intent, we need to be able to cite to how we get that intent.
Well,
where is that
let me
coming
ask you
from?
about that, because I tend to agree with Mr. Sisk's point that he was making with Chief Judge Millen, which was, well, I can't appeal a finding that isn't made. If Judge Marshall says on such and such a date, this treatment took place, and that treatment took place, there's no reason to appeal it. And if on, a week later, there was more treatment and he doesn't even mention it in his findings, you can't appeal the unmentioned treatment.
Well,
I mean, can you?
I agree with there being an issue of appealing unmentioned treatment, but
Or an incomplete mention, or an
or
incomplete recitation of the entire treatment note. Yeah.
I would
Oh.
agree with that.
Okay.
However, finding 21 says Dr. Augrey saw the employee again on May 1, 2023 for a follow-up IME, period. Well, that finding right there deals with the IME, and if what the judge has indicated with regards to that finding doesn't satisfy the appellant's opinion about what that IME showed, if he wanted to say, well, the judge didn't talk about the injections that were done. He talked about CRPS, but he didn't talk about the injections. And in this finding, you'll see that the judge talks about Augrey and the CRPS opinion and that not bringing anything new. This would be the finding that would need to be appealed to say, hey, that IME said more than just that. You forgot this and this and this.
All right, so you're saying, so an incomplete recitation of a medical record doesn't necessarily have to be appealed, but an incomplete recitation of a medical opinion does.
Well, or if there's a statement of what was done at the medical, what the judge said with regard to an injection to the knee. If that medical report said something other than or more than or incorrect, that's the opinion or that's the finding that you address.
All right, well, if it's incorrect, I would certainly want to appeal it if I was the appellant. But if it's, I think Mr. Sis said, well, if it doesn't mention the client's response to the relief of the injection, that doesn't mean that the fact finding is incorrect. It's just incomplete. I'm rather confused by this. By this argument, and because finding 21 is 6 or 7 lines. Dr. Agree's report is 9 pages. Are we only to consider this part of Dr. Agree's opinion or the entire opinion?
Well, the judge considered the entire opinion, and this
Right.
is what he pulled out as important.
Correct. I agree with you there.
And another judge may find something differently, but again, we're dealing with this judge,
All right.
and
So,
if a reasonable person can
Right.
find as he did.
all right. So there's nothing in this finding about Dr. Agree's opinion regarding the knees.
That is correct.
Okay. Does that mean that we don't consider Dr. Agree's opinion regarding the knees then because the judge doesn't mention it at all?
Well, the judge did consider it and
He didn't mention it.
didn't mention it. No,
All right.
he
But
didn't.
can we consider that opinion nevertheless in our review,
Well, I believe
despite the
that
lack of an appeal of this fact finding?
if he had appealed the fact finding and said, well, but Dr. Agree also gave an opinion about the knees, and it's not here.
Right. But he didn't. So are you saying we shouldn't consider Agree's opinion regarding the knee?
Correct.
Okay.
And I'm out of time and blinking, so unless you have
Okay.
additional questions.
Does anyone have any additional questions? Nope.
Okay.
Thank you very much.
Thank you.
Thank you both for your respective presentations. We appreciate your extra time in answering our questions. As usual, you both did an excellent job with your briefs and your presentations today. The record is now closed and the court will issue a decision within 90 days.
Thank you.
difficult to give an appropriate hand gesture to indicate that it's back towards you, which is seemingly wrong, but.
You'd think I would figure it out.
I've been working here for 10 years now, and I still sometimes get it wrong. So
Yesterday I even thought about it. I was like, I did it wrong. Tomorrow I'll do it right.
I will get this.
Take care, Mike. See you.